bahawa pendekatan single wholesale network yang ini memberi manfaat penjimatan yang besar. Syarikat-syarikat telekomunikasi boleh tawar perkhidmatan
berkenaan dengan keputusan Mahkamah Rayuan hari ini.
Datuk Sri, could you say something in English as well, because I think there are newspapers globally who are
to give further elaboration. Thank you.
Thank you, Datuk Sri. Good afternoon again. Needless to say, I was quite shocked with the decision and the reasons provided for that decision. But first of all, we were already disappointed when the court did not want to admit the fresh evidence, the new and fresh evidence that was discovered by us hardly a month ago. Firstly, in relation to Tan Sri Zeti's receiving of money through her family members, not a small amount. The amount recovered by MACC was 64 million, but that is not the amount that family received. They receive perhaps 10 times or 20 times more than that. That too, we have evidence. But with that evidence being shut from being considered by the court, we'll have to take another evidence. And what is also disappointing is the fact that we now know Nick Faisal, because MACC confirmed this, that Nick Faisal received to the tune of almost 2 million Malaysian ringgit. And this is related to 1MDB or SRC money. And why Nick Faisal is so critical is because the learned High Court judge found that Nick Faisal did not benefit anything. That is because neither the learned judge nor we knew at that time that Nick Faisal benefited about 2 million ringgit. So that too has been shut out from the consideration of the Court of Appeal, in spite of the opportunity being given to them. And we have argued enough, so I don't have to say that again and again as to the relevance of those evidence for the consideration of the court. In relation to this morning decision, some primary points need to be stated. Now, first of all, we are quite shocked. And I'm saying this, let me put my position correctly. As lawyers and as litigants, we have to accept whichever court's decision, and we must show respect. And we accept respectfully the decision of the court. But there's nothing in law that says that we cannot criticize the decision of the court. So I'm going to criticize the decision of the court to provide you the reasons why we are disappointed without transgressing into the integrity of the court. First of all, I was disappointed that the court held that there is personal interest of Datuk Sri Najib when he presided over the 2 cabinet meetings that approved the guarantee of the government in relation to the QAP 2 billion and 2 billion loan to SRC. Because I would have thought it was obvious that that interest was official, it can never be personal. In any case, without going further, let me tell you, this is the first time in the history of Malaysia, perhaps even in the history of the world, where a cabinet minister performing a function, no matter what transpired subsequently to his decision, whether the decision was good or bad, there's never been a situation where people can accuse him of having a personal interest in a cabinet decision. And this is especially more interesting because the person who formed SRC was in fact another minister in the Prime Minister's department, and I believe that was Datuk Sri Nur Yaakob. Now that's point number 1. Point number 2, which is a matter of great concern for me. The defense of national interest was accepted by Tan Sri Pandian, was accepted by the former MACC chief Tan Sri Zulkifli Ahmad, was accepted by Tan Sri Sebagai, the former KSN of the Treasury, Ministry of Finance. But in the reconsideration by the High Court judge, and especially by the Court of Appeal this morning, not only they say they did not accept the defense of national interest, which they are entitled to say. Whether they are right or wrong is yet to be determined by the federal court. But what I didn't like was, this is still a matter the court would realize. This is a matter that's going on appeal. This was so said by the court itself yesterday, not today, but yesterday. So in the light of that, I find it disappointing that a kind of a remark made by the court that this is not national interest, but only national embarrassment. Because you can see the defense of national interest did not subsist and we reject it. That will be the end of the matter. But to go further and say this is national embarrassment, I think is unnecessary. And that can cause some serious element of perception on Datuk Sri Najib, considering that the entire conviction and sentence has been stayed. So the effect of such a statement, no doubt in law cannot be defamation, but the effect is like a defamation because it is unnecessary when you say that the defense of national interest doesn't subsist. It is not national interest, but rather national interest. That is something very disappointing, I thought. Number 3, I want to say this. The court made a finding, the Court of Appeal made a finding that Datuk Sri Najib micromanaged SRC. Who gave that evidence? There is no such evidence provided in the SRC trial, not even by Datuk Subo. Because Datuk Subo said he never met Datuk Sri Najib in relation to SRC matter, and he always accepted Nick Faisal's statement as the intermediary, the purported intermediary between the company or the board of directors and the Prime Minister. So nobody has actually met Datuk Sri Najib to confirm and to make a conclusion that Datuk Sri Najib micromanaged SRC. As though a Prime Minister have got so much time to micromanage any company. In fact, there are, if I'm not mistaken, at the time Datuk Sri Najib was the Prime Minister and the Minister of Finance, 85 companies in the wing of the Minister of Finance. how could he micromanage anyone? That is something I thought was glaringly an obvious error. Number 3, this is shocking because this error is made by the High Court judge and propounded by the Court of Appeal. And I thought I should mention this so that you know that we are very serious about our appeal. This is regarding, you remember, there are 6 scanned documents. These scanned documents are in relation to instruction from SRC to the bank, which is Islamic, to do disbursement of the money, which eventually went through 2 other companies and then into Datuk Sri's account. Of course, Datuk Sri is saying he never asked for it, as you know, he never directed it, and he never knew it is SRC money because he has always thought it is money from the Arab donation, which we will come to in a short while. But we have conclusively proven not only these 6 scanned documents, but there were altogether 17 such scanned documents relating to other transactions, apart from the 6 transactions in relation to the politik. We have proven that these scanned documents will follow with the actual document, the original document, the hard copy, to the bank, because the bank requires it. But SRC never sent all the 6 scanned documents to follow up after the scan within 48 hours. But when they sent the original and the scanned copy, which is meant to be identical, happen to be not identical at all. In fact, far from it. It shows that in the hard copy, somebody in a freehand manner, has forged those signatures. And those signatures are completely different from the scanned, cut and paste document that was sent to them. So bearing this in mind, I fail to understand how the Court of Appeal can arrive at this conclusion, which adopted the High Court judgment, that it doesn't matter whether it is scanned or not, as long as there is understanding that the company will instruct by way of scanning procedure, the bank can accept it. That is true if the SRC and the bank has agreed on that matter. But we are going deeper than that. We're saying this is not even their instructions because we have proven beyond doubt, more than 100%, that these documents scanned were cut and paste. If they were cut and paste, as admitted to by Datuk Subuh, and the prosecution never called Nik Faizal, they allowed Nik Faizal to flourish in Jakarta or somewhere in Indonesia without our government making the slightest effort to get him to come to Malaysia and to testify so that we can cross-examine him. So in the context of that, how could you say there is this agreement between the bank and SRC in allowing instruction by the scanned document? We are saying the scanned document itself is a forgery. So how can you say that is part of the contract between the bank and SRC? That is a disappointing finding of fact. I thought, I almost jumped up from my seat when that statement was made. But of course, the Court of Appeal, being an appellate court, they are entitled to make a judgment no matter what. As you can appreciate, when a court of law made a finding, no matter how wrong, finding of fact or finding of law, we have to accept. No matter how difficult it is, we have to swallow the humble pie. Now, the next issue, which was also very shocking, is this. The 3 learned judges quite easily dismissed this defense that there was some Arab donation that came after a very long negotiation with King Abdullah on one particular day, which we brought about many witnesses, including 2 cabinet ministers. You remember there was a Minister of Foreign Affairs, Dr. Hanifa Aman, and there was a minister in the Prime Minister's office in charge of Agama Islam and Tabung Haji, Datuk Sri K. And there was also the ambassador attached to the Saudi to the Saudi state, which was Professor Syed Omar, Professor Syed Omar, who all testified that there was this meeting with King Abdullah. And my client testified that King Abdullah said he will give some kind of assistance, and which was finally confirmed by Jolo to Datuk Sri Najib that the assistance will be in the form of financial assistance. All these were not touched upon. And there were 4 letters subsequent to the death of King Abdullah, because King Abdullah died. So there were a prince, or more than one prince, who wrote a letter. I think one of them was Prince Al Saud. They wrote 4 letters that confirmed donations was coming. Following what was the meeting between the late King Abdullah and my client. Now, it is not just that. If you dismiss just the 4 letters, you must have good reason. We know we could not call the person who signed the letters, but neither could the government, because they sent MACC chief and senior MACC officers to Riyadh to interview this Prince Al Saud. And they took statement from Prince Al Saud, and they brought the statement back. And we managed to extract this evidence from that particular MACC officer. They confirmed. They met Prince Al Saud. They confirmed from Prince Al Saud that the 4 letters came from him. What else can we do? If you cannot produce Prince Al Saud, do you expect us to be able to produce it? We are not a country. We are just individuals. Datuk Sri Najib was no longer a prime minister. So to say that we never complied with the proving of the document is to put unnecessary burden on us, because MACC has confirmed it and they have testified in evidence. But what is more important is this: the court was silent, both the High Court as well as the Court of Appeal, that the initial 7 tranches, it's either 7 or 9, but I think 7 tranches, constituting 642 million ringgit, came directly from Riyadh, the Ministry of Finance, Riyadh of Saudi. They sent this money into the account of Datuk Sri Najib. Now, if we're talking about knowledge, let's assume Datuk Sri Najib knew the initial money came from Riyadh. What do you expect him to think? That these money that came from Riyadh is consonant with what was agreed with the Saudi king, and subsequent money that came, even if it comes from other outfits, isn't it reasonable for Datuk Sri Najib to take these other outfits are outfits of the Saudi government? They may use commercial entities, they may use the Riyadh entities, Ministry of Finance, and so on and so on. But this was not addressed by the court at all. So I am extremely disappointed. And I'm just pointing to you the big areas of concern. There are altogether 40 areas of concern that we will raise with the federal government. Now, I don't think I should go any further except to end with this one other fact. Apart from the matters which I just mentioned, his, what would I say, his lack of knowledge, my client's lack of knowledge that the money came from SRC or from any wrong entity, or that it is illegal proceeds of crime, is the culminating act by my client after the 14th, after the general election, after the general election, my client returned the 620 million US He received something like 685 US million, and he returned 620 million US, having used some of it for purposes of the general election. Now, interestingly, when he returned the 620 million, because of the favorable exchange rate between US and Malaysian currency, that money became 2.6 billion ringgit again. So the question mark is, why would someone who is supposed to steal money return the money from the same entity that sent it to him from Singapore? Why should he return? The money having traveled, assuming throughout the globe, came back to Singapore, then he brought it back right in the backyard of his own home, which is Islamic. And then having used some for the election, very small amount, he sent it back. Is that a pathology of someone who is corrupt, who is stealing money from the government pocket? I think I will stop there for question time. Thank you very much. That you want to ask either to Datuk Sri Najib or to me, you're most welcome.
I'll just put up.
I understand there are some questions from the chat box. I'm going to read it for your benefit, and then I'll see who is going to answer. It says here, good afternoon, Tan Sri. This is from Cheong, from Sinchu, Delhi. Cheong from Sinchu, Delhi. It says, good afternoon, Tan Sri. Can Datuk Sri Najib contest in the upcoming election, even though still pending for federal court appeal? Can I invite Datuk Sri Najib to answer that question, sir?
On that question, I'd like to say that we will cross the bridge when we come to it. First of all, the general election, we don't know when it is. And there are political considerations to be made, personal considerations. So I will leave it when the time comes.
Any more questions, please? You can send it by way of chat, or you can ask directly here.
Hi, Datuk Sri Najib. Could you hear me? This is Kao from China from Malaysiakini. Just now the judges mentioned about the national embarrassment, and then your Shafi made comment about it. What is your take when such accusation comment say on you? Thanks.
Of course, I am very, very disappointed with that because throughout my career, I've always been focused on how to promote national interest. And as you know, during my tenure as Prime Minister, as just an example, the total assets of the country under my watch grew from 800 million to 2 trillion ringgit. Therefore, I created a lot of wealth for the country. That's just one example. And if you talk about national embarrassment, there are other incidents or other issues, other scandalous, I would say, issues For example, the scandal surrounding the foreign exchange, forex issue, which led to a loss of about 31 billion ringgit. If you put in that context, isn't that a much more colossal national embarrassment? I just like to put it in proper perspective.
Add on to that, the reason why I picked that particular phrase from the judgment to highlight to you is because of this. Judgment are supposed to be clinical. Judgment are not supposed to, it is supposed to have what they call the content effect. The content must have effect. It is not supposed to have the sound effect. I thought the statement, it is a national embarrassment, was to achieve the sound effect rather than a content effect. There is another question that has come in from the chat group. This is from Moose, Benar News, to everyone. Salam Tan Sri, what is the next course of action? When are you going to file in the appeal to the federal court? Okay, this is a question that I should answer straight away. As we are speaking now, the appeal notice is being filed. We wanted to file it as we were submitting in the federal court, in the court of appeal just now, but there was a technical glitch, but now it is being filed. Any other question?
The question or the remarks that I made with respect to the foreign forex scandal, as you know, during my tenure, the government set up a Royal Commission, RCI, to investigate the whole episode of the forex 31 billion loss. Subsequently, the PH government made a decision not to proceed and to classify as no further action. You know, a loss of 31 billion ringgit has now or was classified as no further action. Just to put it in a proper perspective again.
Darishi Najib and Tan Sri Shafi, if both of you are not happy with the remarks by the judges, what action can you do on it?
All right. Can I, since it's a very technical point, I will answer first. You see, we are pushing for the appeal in the federal court. In the course of the appeal in the federal court, and assuming the federal court sees our point of view, that remark can be expanded because that remark is unnecessary to the judgment of the court of appeal.
Last few questions. Okay, if there are no more questions, thank you, everyone. Sorry, there are two more questions. There are two more questions.
Two more, sorry. Yeah. One is from Malay Mail, Emmanuel, to everyone. Would this decision have any bearing on Datuk Sri Najib's other ongoing trials? The answer is of technicality, one trial is irrelevant to the other trial. In fact, you cannot even bring matters of this conviction or elements of this conviction in any other trial because they are not relevant. So it does not have any bearing. Having said that, I hope that judges hearing all other trials will maintain their independence and impartiality because, as you know, judges are also human. So they need to remind themselves to be always vigilant in favor of independence and impartiality. And there is a second question from Usha Daniel to everyone. Say hi, Tan Sri. How confident is the defense with appeal at federal court? As I have said, you know, I have attacked rather vigorously the judgment of the High Court. And I have said this in the Court of Appeal. In fact, the Court of Appeal, which was 6 months ago when we argued this is 6 months later the judgment came out. I have said to the Court of Appeal that the judgment of the High Court was incompetent because there were so many areas that we thought the learned High Court judge made mistakes of law and mistakes of fact. I was extremely confident then, and I am extremely confident now. There's not a shred that has reduced from my confidence. As you know, in any system of trial and two appellate process, as in Malaysia, we have had not just one or two. In fact, I would say many. There are so many cases like that that it troubles me to say that we have got cases where the High Court convict, the Court of Appeal convict, and the Federal Court threw it up. Reverse the entire judgment. I have met that in my life so many times, maybe 50% of the time that I feel. So I am not troubled by the concurrent conviction. My confidence in this case is alive and has not reduced, not a bit. And as you know, even the learned High Court judge admitted in his grounds of judgment, this is a case that poses serious difficulty of law and fact. Even the law, interpretation of the law, he says this is the first time ever in the history of Malaysia such a law is being interpreted. So as you can appreciate, it is not only a matter of mistake of fact or a doubt as to the facts that you must give the doubt in favor of the accused. If there is a doubt, you resolve it in favor of the accused. But they also say that if there is a doubt about the position of law to be interpreted, that doubt too must be resolved in favor of the accused. I hope they would find in their heart, in the federal court, to apply this principle rigid. Thank you.
Last questions, anyone? Okay, thank you very much.
Thank you.
Thank you very much.